Oh, okay. If Michael Sly could come forward. Thanks.
Thank you.
I thought I saw you sneaking out.
I was bladder failed.
Okay.
I'm sorry. These guys know what I'm talking about. Good afternoon, Mr. Chairman and committee members. I'm Mike Slack. I'm a private practice attorney here in Austin, Texas. This is where I sleep. I usually am litigating or practicing law some other place. My area of specialty for more than 30 years now has been aviation. I'm an active pilot. I regularly fly about 100 to 150 hours a year. And I am going to talk about fly-ins with you this afternoon, Mr. Clark. I want to start off because there's a lot of confusion that has set in here concerning what may be the problem or what the landscape is that we're talking about.
Just like if you could go ahead and state that you're supposed to build.
Okay. Sorry. That was so well introduced for me by others that I dropped the ball on that. There are, as indicated, about 1,600 airports that are what are referred to as private use airports. That's different from a public use airport like Austin, DFW, or even some privately owned airports where the public can land. In a private use airport that's registered, that means information has been sent to the federal government, then the federal government has information about the runway, about the length of the runways, the surface, the conditions, etc., that's accessible to the pilot. Now, in a public use airport, pilots have information to weather information, traffic information, multiple sources of information, so that as they are flying their flight and approaching their destination, they can readily update and refresh that information. In some private use airports, there's not local weather information, there's not traffic information, there's not a controller, usually an airport with some degree of improvement around it, which you can find if you look up that airport. There's yet another category of private airports that are not registered airports that are in this category of what's called backcountry airports. They're neither registered nor maintained. They can be a creek bottom. They can be a ranch road. They can be a grass strip. They're just out there on property, and pilots may avail themselves of that or not. Now, the question was asked about this problem. There has never been any reliable anecdotal information to suggest that people aren't giving permission to land on their registered private use airstrips because of the lack of immunity from airplanes landing on them. There are very many of the 1,600 registered airports where the owner simply doesn't want somebody landing there, period. They have a ranch, they have an airstrip, the only airplane they want landing on that is their private jet or their turboprop. There may be some airports, and I'll be the first to confess, where the owner may want to have airplanes come in for some reason. The flying example may be a good example of that. Or there may be 3 or 4 acquaintances of the landowner that they would like to have come in. I've landed at private use airports where I had to get permission ahead of time. I have not been asked the liability question yet, but each instance I was ready with an answer. It's a very simple answer. For little or no money, the pilot can put the private airport owner on their policy as an additional insured. If I want to fly into your ranch and land on your airport, you give me permission, then I call up my agent, say I want to fly into Mr. Sheets Airport, put him on as an additional insured, and they say, what's the name of his ranch? And it's the so-and-so ranch. You're an additional insured. You're protected with insurance. If I don't get your permission and I fly into a private use airport, I'm a trespasser. In Texas, a trespasser, the landowner owes the trespasser no duty greater than willful wanton negligence and gross negligence. If it is a landing by permission on a public or private airport premises, it is all by permission, straight up permission, and there's a bad event, a crash, then you're in a Chapter 33 situation. proportionate responsibility applies. It's negligence. Question of the landowner's negligence, question of the pilot's negligence. In the vast majority of the cases that I've handled where there was a bad outcome at an airport, usually a unregistered private airport, I'm talking to you about one, there was landowner liability involved, but it was relatively minor compared to the proportionate responsibility of the pilot. But let's think through what happens in that type of a situation under Texas law. If a pilot crashes the airplane, and let me back up from this just 1 second to say, if you want to write a bill that says if a pilot calls Mr. Raymond and asks permission to land at his ranch airstrip, and he gives it to me, and I'm by myself and I wreck that airplane and something bad happens to me, if you want to limit my liability as a pilot, go right ahead and do that. I don't really give a rip about protecting the pilots that screw up and the only consequences to themselves. What I'm going to get to in a second is it's the passengers and the persons on the ground. But if we go back to Chapter 33, and there's a bad event, and I'm representing the pilot, or representing the passenger on board, and a lawsuit is filed in Travis County against the pilot, or West Texas County against the pilot, guess what happens? The pilot names the landowner as a responsible third party. Then it's up to me to name the landowner, otherwise I'll have an uncompensated loss. I'll have an empty chair. So it's really important to understand the context in which you're operating here. Chapter 33, particularly with responsible third parties, has a very significant dimension in allocating the loss in the event of a bad outcome. If you immunize the landowner in this situation, landowner is 30% responsible, pilot 70% responsible, with just a $1 million loss, just a hypothetical $1 million loss. Let's just say it's all for lost wages. $1 million. If you immunize the landowner on a 30% allocation responsibility, 30% of that is uncompensated loss. As attorneys, you know what that means. If it's a property damage claim, 30% is uncompensated. If there's a big loan on that, that's going to upset the bank. 30% will go uncompensated. Now let's talk about passengers and persons on the ground, because the most memorable case I handled, and they knew I'd come talk about cases, because I think cases are what shape the civil justice system and give us something to talk about. The most memorable case were a group of guys out of the Metroplex wanted to fly to the now closed McGeehee's Catfish Restaurant runway up in Marietta, Oklahoma. The pilots, Mr. Clardy, that I've encountered in these cases are diligent people. They try hard. They try to do their best job. Sometimes things happen at the other end of the flight, particularly when you don't have current information. The information that you would ordinarily get en route isn't available to you when you get to a remote strip like McGeehee's. And the pilot touched down, and there had been a big rain, and some other things had happened. They had a ravine off to the right anyway. The right gear sunk into the ground. It caught, snapped off, the airplane cartwheeled, went off a 60-foot ravine and burned. I've got the NTSB report right here. My client was trapped in the fire. Now, I'm going to make sure that every one of you gets a copy of a 4-minute video that was done over the litany of crashes that had happened at that airport. But in the case I handled, the landowner picked up part of the responsibility. The pilot shouldered a lot of the responsibility. But the system allocated the loss in a way so that the landowner did not walk without some accountability, and the pilot did not walk without some accountability to the final outcome under the facts of that case.
Mr. Chairman. Thank you, sir. Sir, just real quick so we can clarify this case, and I don't know any of the facts of this case. Who did the strip belong to?
The Catfish restaurant.
So they were using it for commercial purposes.
That's right.
So that's completely different than a private landowner who's allowing someone to come in and they're not being compensated for the person landing on the airstrip, isn't it?
It may be that your bill, the substitute you have in front of you, doesn't limit it to, it just says aviation activities.
But doesn't the whole recreational use statute go to non-compensation?
The way this statute has evolved to this point, and I've been fiddling with this bill since probably 87. I don't believe the bill today works the way it was intended. But if this committee substitutes enacted, it is going to reach commercial and non-commercial activities.
So if it was tailored in such a way to where it didn't address commercial activities and only recreational activities, and there was no compensation, such as the Alaska version of this law, wouldn't that address your concerns then?
I haven't got to the passengers. What are you going to do about the passengers, Mr. Sheets?
Well, they get to go. We just heard 90% of these pilots are carrying insurance.
Well, in the 3 weeks it was that I was last in Senator Rodriguez's office with Mr. Snodgrass, at the time he didn't have insurance and he owned an airplane. He doesn't own an airplane that has insurance. Now, I don't know what's going on with the statistics, but I'll tell you this. In my experience, when I go representing families, there are a lot in general aviation, 2 scenarios I see a lot. Uninsured pilots and pilots with what we call the 100,000 sublimited policy. And those policies don't do a lot to protect the interest. The pilot thinks they get $1 million policy. Are you familiar with sublimited policies in aviation?
No, I'm not.
Okay. It's written as a $1 million policy, but in the fine print it says it's sublimited to $100,000 per passenger. Okay. So effectively...
So is this for recreational use or is this for commercial use of aviation?
It's an aviation policy.
Okay.
So
it doesn't differentiate between general aviation and commercial aviation?
The policy will not apply if you're flying for a commercial purpose like a charter.
Okay, so if you're charging your passengers to fly, then you can't use this policy.
That's right. You shouldn't be doing it anyway if you're a private pilot.
Okay.
Only certain contexts can you do that.
Then let's go back to the catfish restaurant, whatever. In that case, that landing strip belonged to a commercial venture that was making money off people landing. They go eat catfish at the restaurant. Yeah. And so they had a duty to maintain the runway.
Well, they had a duty as it was. There was no special law in place for them.
Right.
They had a duty of ordinary care, just like anyone else.
Okay, so if I'm a rancher, because you wanted to call me a rancher, so let's say I'm a rancher, and Mr. Clardy asked to land on my strip, and it's a couple weeks, said, hey, you know what, you can land on my strip anytime you want. And the weather's bad, because in this case, you used the weather as a scenario. I mean, that's an act of God situation. Me as a landowner, why am I responsible for an act of God situation on a landing strip, especially when it's recreational?
I didn't say it was an act of God. I said there were facts that suggested that the landowner should have, and I want you to see the video that I'm going to send you, that the landowner should have taken measures to eliminate dangers on the airport that were not ascertainable by the pilot.
Again, because he's making money off of the venture. In this case, he's asking me a favor. He says, hey, Mr. Sheets, I just want to land on your airstrip. No money, exchanges hands. He's just my friend. Hey, yeah, Travis, come land anytime you want. I mean, at that point, isn't he assuming the responsibility if we pass this law because it's recreational use?
I'm going to go back. If it's between a pilot and a landowner, I have no problem with that immunity being extended and accepted so that it only affects the pilot's interest and the landowner's interest. Where I disagree with you is as to passengers and persons on the ground.
Okay. So what cases do we have involving the situation of recreational use where we have passengers on the ground? Do you have those cases?
Well, let's talk about what you're asking about. You say a recreational use. Are you talking about...
As defined by this bill, what recreational use would be?
That terminology is part of the problem because the recreational use is very broad. In aviation, non-commercial flying is typically defined as by what we call Part 91. Okay, that is general aviation. There are lots of examples where people operating their airplane under Part 91, of which the recreational definition in the statute fits within, where people are hurt and landing at private airplanes. I can't tell you how many of those in which the landowner would have or did have responsibility. I'm just saying if you there's a bucket that you could put cases in that are representative. If we go, for example, I can get some NTSB crash reports of the Catfish restaurant.
But that's commercial. Let's talk about recreational.
I was about to say, there are also landing strips that are publicized on their website that have numerous crashes that have occurred by people flying into the backcountry and crashing. And a lot of these are very well publicized. So I can get you that information. I can get you a lot of examples of people. For example, one of the most famous crashes occurred at Johnson Creek, Idaho. It's a backcountry strip. In order to land at that strip, what you have to do is hug the right side next to the mountains, because it's a tight canyon. Do a 180 while looking back to see if there's traffic. You're flying towards terrain. Bend it around and land at this grass strip. Distractions of terrain, distractions of trees, distractions of other traffic, changes in weather conditions causes pilots to get distracted. 2 airplanes locked up crashed and a 2-year-old child died.
Okay, but how is that the landowner's responsibility? And then let's put you on the same standard that Mr. Raymond put the other witnesses on. Give us a Texas example.
All right. Let me finish that example, because I think it could occur anywhere in the United States.
Do we have that terrain? Any airstrips with those terrain here in Texas?
Yes, you do. Okay. In the Big Bend area. There's several strips out there where you have those same terrain conditions, poor lighting, actually no light, and where the mountains create shadows, etc. Those same conditions, those same risks are present in lots of places in Texas. Okay. What happened after these planes crashed, and this was on public land, but I'm going to take that and lift it and put it on private land.
Okay, so that would be outside the statute then.
I'm giving you a factual scenario, but I'm going to change it.
But it's not applicable.
I'm sorry?
But it's not applicable to this statute.
All right, let me back up this way. I'm going to give you a hypothetical of 2 airplanes crashing just like they did at Johnson Creek, Idaho. Okay? They crashed, a 2-year-old child was killed. The airplanes were tangled together, crumpled up on the runway. Airplanes continue to come in. The runway was not closed. There were probably 60 or 70 airplanes on the field. By the grace of God, those 2 airplanes that tied up did not crash into other airplanes or other people on the ground. Okay. You don't want 2 airplanes traveling at the speed airplanes travel, carrying the fuel they carry, colliding or crashing in the proximity that these planes were crashing next to other airplanes and the public.
So who controlled that airstrip?
That was public land.
Okay.
If you have a private land situation, all I'm suggesting is that the landowner, if the landowner keeps giving permission, or the landowner has knowledge that this has happened, you might have a situation, a factual situation, where the landowner has a duty to act.
You don't think that would fall under willful or gross negligence?
No. Aviation cases, there's really no such thing as willful and wanton.
Okay.
There really isn't. The reason is there's always evidence of diligence and efforts being made to fly safely. It's just that you get somebody that deviates slightly, they make a mistake, they make a negligent mistake, but we don't see malicious or grossly negligent.
Now, you have the advantage of being a pilot and an attorney, correct?
I've heard that.
All right, so you understand about insurance coverage, you understand about liability waivers, you understand all about all this. Do you think, looking over your left shoulder, do you think that those private pilots over there who for the most part, they're talking about they're general aviators, they're not commercial aviators, do you think they have the knowledge to call and add people as additional insureds to their policy, to have them fill out liability waivers? And frankly, when you're just flying around sometimes and I decide, hey, I'm flying over Travis's property, it may be a good idea to go see him. I radio down to him and says, yeah, go ahead and land. How am I going to call and add him as an additional insured, and how the heck am I going to have him fill out a liability waiver while I'm in the air and he's on the ground?
Well, I'm just saying, before you take the step of changing Texas law, if we were to expend the energy to educate pilots to the fact that they could do that, we got the help of AOPA rather than opposing insurance efforts to enroll pilots, rather than opposing requiring pilots to take insurance like we do cars. If we got AOPA to put in their magazine every month or once in a while something about doing that, pilots would start doing it.
Well, why don't I mean, I could flip this around, turn it on you, and hey, I mean, we're attorneys, we have to market our services. Why don't you market your services and provide a disclaimer or a public announcement to pilots as well? I mean,
what do you mean?
Well, you could put an advertisement saying, hey, you might want to consider this.
Well, I've advised lots of pilots, lots of operators, many members of this House.
Yeah, but why are you putting it on the shoulders of AOPA?
I'm just saying AOPA communicates with something like 800,000 pilots, and they do it regularly. Why not take advantage of that communication mechanism? I mean, if they want to be a partner in safety, and a partner in communicating, and what we want to do is make sure that losses are compensated. Why not all pull together stakeholders and try to solve this problem in a way that doesn't immunize somebody and create a bad outcome in an unintended manner?
Right. Well, and the one distinction I would say with your comments, though, is that insurance doesn't equate to safety. Insurance equates to management of risk.
I disagree. Insurance does equate to safety because, you know what? When it comes time to renew your pilot's insurance, if you're not doing things right, your agent and the underwriter is going to have a conversation with you. And I always tell people when they call and ask me for advice, and I've given advice to members of this House, I've given advice to members of the Spiceway Pilot Association, I've given advice to a lot of people who fly and are in aviation business, that if the insurance people balk at renewal, then you better ask them, what's the problem, and fix it. Because it probably means that you're engaging in a risk that is making them uncomfortable. Now, I promise Mr. Clardy I'll address the flying issue. Okay? And I think there's a comparable solution to fly-ins. Because I've worked with people, and Mr. Clardy, I saw it wasn't a fly-in, but it was a terrible example of what could happen when there's a large congregation of people at an aviation event. I represent a number of people that were affected by the Reno air disaster. And for those of you that may or may not remember it, that's an air race that happens every year in Reno, Nevada. And in September 2011, one of the race planes suffered a structural failure and crashed near the spectator area. At the time, the race course directed the energy of the race planes directly towards the primary spectator area.
Sorry, let me get you, if you would, to try to speak more into the mic.
Okay, I'm sorry.
I've got to keep the rep.
I'm sorry.
So, okay.
Normally used to having the lapel and not the boom mic. So, because that energy was directed at the spectators, and this is the point about risk and a risk of airplanes crashing in proximity to spectators and the public, it releases a lot of energy and a lot of shrapnel almost instantaneously, so you get essentially battle wounds. There were traumatic amputations, there was traumatic decapitation, there were people that had buried shrapnel in their bodies. Their injuries were horrible. Why? Because the energy of the airplane that crashed in proximity to them basically sprayed them like a bomb would spray a soldier in combat. These airplanes release a ton of energy, kinetic energy. They have kinetic energy, and when they stop suddenly, kinetic energy is converted to heat and release of the material as it explodes outward. The pictures from aviation cases are not for the weak of heart, but I'm getting to fly-ins by telling you that when we worked on that problem, we sat down with the Reno Air Race Association and said, look, you're doing this right, you had insurance. They were able to get event insurance, just like fly-ins and air shows can get event insurance, just like outdoor concerts can get event insurance. They had event insurance. But we said, and the insurance company was in the dialogue, let's change the race course so that energy is not directed towards the crowd. Now, if your friend wants to have the fly-in, what the insurance company, if he calls and says, I'd like to have this fly-in, and he speaks to the pilots that are coming in and says, I'm going to charge $10 a head to cover my cost of insurance, whatever it is. The insurance people are actually going to have a conversation with him about, okay, what direction, where are your runways, etc. And it's actually healthy, Mr. Sheets, to the safety equation. The underwriters on the front end can actually be beneficial. And in the aviation industry, I found that they can be very beneficial on the front end. And they were very constructive in the Reno case in saying, we want to continue underwriting the Reno Air Race Association. And these are positive suggestions about changing the way the planes fly so they don't direct at the crowd in future races. So the answer is, I think you can deal with flying very simply without having to go the immunity route with event insurance and bringing, and then that cost can be distributed to the pilots that are flying in, or if the landowner simply wants to do it as a beneficial gesture, it is relatively inexpensive and relatively available. Now, that's advice I've given to somebody that wanted to do the same thing. And generally speaking, it's a commodity that's inexpensive. And but again, the insurance people will ask some questions that I think are constructive to the safety equation. So, I'm not going to go on anymore. Under present law, there's not a tilted playing field in that under the facts, whatever they are, Mr. Sheets, that bring us to a particularly bad occurrence, those facts are evaluated and the allocation responsibility is determined. The same rules for the landowner, the same rules for the pilot, except that the pilot bears a heightened degree of care because of federal law. Federal law imposes on the pilot a heightened degree of care, almost means without certainty they'll bear 60 to 90% of the responsibility under any circumstance. So I'm opposed to the bill. I think the backcountry flying brings unique risks. And I think we better be very careful about how we approach this because of the immunity that the consequences of immunity that will result.
Mr. Chairman, I'll make it very brief. I just, I'm looking at various states and what their laws are as it relates to recreational use and landing aircraft. And I mean, Alaska, for so many reasons, seems to be the poster child because, general aviation, I think, higher percentage of citizens in that state fly than any other state, I think.
It is a way of life.
It's just because it's so darn big there.
They can't. They don't have an infrastructure of roads. They have to use bush planes to get around.
And do you have examples? And I'll open it up to any state any state that has recreational use that includes aviation. Have you had any situations where giving the landowner immunity has resulted in someone not being able to recover their damages?
I don't know, but I will ask and I will respond to you. Okay. I will seek to find an example in an existing rec use state involving aviation where there was a shifting of or uncompensated loss or some consequence. I'll sure try to find out.
Okay.
You bet.
Thank you, sir.
You bet. Okay. I'm happy to collaborate with any of you or any of the proponents of the bill to see what we can do on this.
We appreciate you being here.
Thank you.